Good afternoon and welcome to the last installment of our discussion of source of law in Ghana. Those of you who have been following these discussions, you will have noticed that we decided to break the source of Ghana into smaller units for detailed discussions. And as I've indicated to you before, we follow how we have actually treated it in chapter 3 of our book, Ghana Legal System and Legal Method, volume 1, the second edition. So after this session, the next session, we're going to have discussion of core structure. Now, the approach I am using is such that once we have discussed the particular topic, and once you've read the chapter and various references alluded to, you should be in a position to answer any question meaningfully, insofar as they relate to the topics that we are discussing. Good. So having said that, we are discussing the common law of Ghana, which is the last segment of source of law in Ghana. So before we do that, let me remind you that the book that I'll be telling you about is out now. So if you go to Kingdom Bookshop, you get a copy, or if you go to some vendors, my office and in Kumasi, and also those who sell some of the law books will get it. But there's a few things I should like to draw your attention to. So the second edition, we have actually put them in two volumes. So volume 1 discusses a number of topics which are properly legal system. But volume 2, which is supposed to be legal method, has maybe about 2 topics of legal system included. So in the volume 2, we discuss criminal procedure, we discuss the civil justice system, we discuss ADL, the doctrine of judicial precedent, we discuss teaching case analysis, we discuss introduction of law students to practical application of judicial precedent doctrine through the use of IPAC or IRAC in answering problem-based questions. And we discuss statutory interpretation. We discuss introduction to jurisprudence or philosophy of law in detail. And we also discuss legal English and legal writing, as well as presentation skills and also mooting skills. So those are what you find in the volume 2. The volume 2 is not out yet. Hopefully in 2 weeks' time, that should be out. But what we have out now is volume 1. There's a few things to note about the new book. We have added the questions, and the questions that I've included are supposed to enable you to revise what you are learning. So for example, when you go to chapter 3, we have these questions there, like describe the stages involved in the parliamentary process of passing a bill, or how does the common law of England differ from the common law of Ghana? Or question 3, the legal system of Ghana is pluralistic, discuss. And question 4, explain the maxim where the equities are equal, the law shall prevail, setting as its rational and practical application by courts in Ghana. We also have problem-based question as part of the revision question for chapter 3. So we have like a scenario, for example, like this. If you get the book, I mean, these things, I guess copy and paste from the book, everything is there. So just to give you the idea that there are new features and also new content. Okay, so coming back to our topic for this afternoon, the common law of Ghana, we first of all have to understand exactly what the common law of Ghana is. And you notice that if you look at Article 11 Clause 2 of the 1992 Constitution, it has defined the common law of Ghana to include, quote, the rules of law generally known as the common law, the rules generally known as the doctrines of equity and the rules of customary law, including those determined by the Superior Court of Judicature. So you notice that the common law of Ghana has got a number of components. Rules of common law of England, if you like, that is the common law as developed originally in England and variously refined. And then the doctrines of equity. The doctrines of equity, and in our own homeland, our customary law. Our customary law. And the customary law are also two kinds. The customary law, which have, for example, been determined by the Superior Court of Judicature, or customary law, which you have to go through the process of judicial ascertainment of their content, using like section 55, 54, 56 of the Courts Act 1993 at 459 as amended. So let us take note of that. So historically, as we ought to have known by now, the common law originated in England after the famous Norman conquest of the 11th century, that is 1066 AD. And how did it develop? The story is pretty straightforward, and the story is well known and well told. As you remember, before the Norman conquest, England was under, if you like, the feudalism, because you didn't have, really over centralized, authority, various feudal laws and all that, depending upon, they were in charge of, certain portions of the territory and people who lived there. Now, when after the Norman conquest, the king, the leader at the time, sought to really assert his authority. And to do that, you needed to have peace, in the realm. And the way to have peace is to ensure that people are law-abiding. So what do? Royal officials were sent around the various communities in order to settle disputes so that there will be peace and harmony in the realm. Now, when they went, apart from maybe occasionally, where maybe the king had decreed something and you have some form of what we call statutory enactment like today, most of the disputes were actually referable or adjudicated using local customs of the people. So the people's own, if you like, local custom regarding things, those were the things the royal officials used in actually settling disputes. Initially, they did not have recording or writing down of their decisions, but over time, they adopted the practice of recording their decisions. If I say recording, not like recording it on tape or anything, but like writing down their decisions. And that brought about the practice of having, pack or pile or accumulation of various decisions. And they carried these things with them wherever they went, so that if they went to town B and certain cases came before them, they will remember that, but when we're in town A, a case which is very similar, like the one we are presented with, was presented. So let us go through our books and find out how we decided that case, so that since the facts of that case very materially similar to what we have now, we don't have to reinvent the wheel. We have to just apply the solution that we gave. Now, that practice of actually going through their books to find out what they decided in order to use the past decisions to help them to resolve similar but new cases is what gave rise to what we call the stare decisis or judicial precedent. So stare decisis stand by settled things or stand by decisions which are already made. If something has been decided already, don't ignore it and decide it anew. Stick to that. Ensure consistency. Now, related to the kind of justice system the royal officials were actually administering was what we call the trial by peers. You know, they also adopted the practice of involving the local people in settling disputes. Now, the local people are selected in, and that's developed into what we call the jury. And they will listen to the case and use their everyday experience and common sense appreciation to make a determination as to whether somebody did something wrong or somebody did something right. So that was the trial by peers or the jury system. So in a nutshell, that is how the common law, if you like, originally developed. And of course, this will subsequently be spread to other countries when Britain decided to colonize other countries. And that is how the common law spread to places including Ghana. But there were certain difficulties associated with the common law as developed from the way that we have briefly narrated it. Now, what the royal officials were doing, they introduced what we call the rate system. The rate system simply meant that they design, if you like, various forms, okay? They design various forms so that if you wanted to bring your case before them, you needed to identify and get the appropriate form, which enables you to present the story of your case so that it could be put before the court. So that is the rate system. It's a bit like a pigeonhole. When you go to pigeonhole, various pigeonholes are there. So just like you try to find the most suitable one, which you can slot or subsume your case under. But so claims or cases had to fit existing rates. And that was a big challenge. What does that mean? That is to say that when they design the rate, it's not the case that they kept updating the rates to accommodate new type of cases, new development. No. The ones they have been developed and they were available there, that was it. But no, life is not static. Human beings, we are dynamic, and society itself is dynamic. Situations keep evolving, and there may be certain nuances, certain details, and certain novelties or new things which may not fit into any of the existing form or any of the existing rates. And if you could not get a suitable rate for your case, what it simply meant is that you could not bring it before the royal officials or before the courts. So that was how complicated it was. So it was really rigid, complex, and also expensive. Now, the other difficulty is that if you succeeded even in identifying appropriate rate for your case, in terms of remedy being the solution that you want. Of course, if you have a case and you go to court, you want the solution, that is why you're going to court. So that is a remedy you are looking for. Now, for the common law, as evolved, the remedy which was available was monetary compensation, so damages. So if you were successful in proving your claim against your opponent, you'll be given appropriate quantum or measure of damages, as it were. So these were major problems. But before we move on to look at how these problems actually gave way to what we call the doctrine of equity, some may wonder, so the name or the term common law, how did it come about? The term common law, as you have learned from your LLB by now, simply meant a description of phenomenon. That is, the fact that when you look around most of the communities in what we call England, virtually the same body of law or body of legal principles were being applied. And how was it so? It was simply because the courts or the judges were practicing stare decisis, judicial precedent. Because if, for example, you've been to 40 communities, right? And if you have compiled the decisions that you gave in previous communities, as you go around and you keep applying those decisions to similar ones which are presented to you, it would not be surprising to find that over a period of time, you will notice that in terms of decisional law, in terms of principles that have been laid down in decided cases, you have a uniform set running through the entire country. And that is why the term common law came about. The law which is common to almost every part of the country. So having said that, there were problems with the how the common law developed, especially into race system and all that. They've also even not talked about abuses of the jury system, how people who were rich would actually bribe jurors to render verdicts which were in their favor, contrary to the evidence and all that. So these were rare difficulty. And in some cases, we had perversion of order of justice. So these difficulties led to the development of equity to address the dissatisfaction or the common law effects. So therefore, equity, which we understand to be body of principles that reflect fairness, principles that are in accord with right or good conscience, principles which are supposed to advance justice, develop to mitigate, to ameliorate, or to tone down the harshness or the rigor of the common law. Now, there's a development. When the king, don't forget that at that time, English society was largely Christian, unlike now. So the king will be someone who is also interested in affairs of God, a Christian and all that. Now, people who felt that they had been given a raw deal in the sense of not getting true justice when they went to the common law court would like to petition or go straight to the king for the king to actually look into their matter again, and trusting that the king is a person of fairness, justice, someone who follows his conscience, he will do what is right. So the king will sidestep the technicalities or the technical stretches of the common law and render decisions which he believed were in accord with fairness, in accord with good conscience and all that. Now, that practice of seeking intervention of the king or the monarch became so popular that a lot of disputants or litigants who were aggrieved by the imperfection of the common law system, decided to avail themselves of the opportunity of seeking intervention of the king. And of course, the king is not there to only deal with people's disputes. The king has so many other responsibilities as the leader of the society. So the king became overwhelmed, and for that matter, decided to appoint an official whose responsibility would be to look at cases of those who had actually petitioned the king to look into their matters. And that person was what you call like the chancellor. The chancellor. Initially, the chancellor was a bishop, a high, ranking religious figure. And because the equity is really based upon right conscience and all that, if you put the bishop there, then the bishop wants to use his conscience in the sense of fairness and justice. So there used to be a saying that equity varied with the foot of the chancellor. So that if you had a chancellor who had a short foot, maybe some of the principles would be different from if you had a chancellor who had a long foot, as it were. So someone would say that the principles of equity was as as good or as many or as fair or as long as the chancellor's foot. And what that simply means is that the principles of equity were not cast in stone. They were very loose in the sense that you are applying general notions of fairness and justice with conscience. And for that matter, depending upon who the chancellor was, you could have some variations here and there. So let's keep that in mind. Now, what that meant was that over a period of time, you could discern or you could see certain principles or even certain sayings, certain maxims or precepts associated with the kind of justice which was rendered in the court of equity, in the chancellor's court. So these are what we call the maxims and principles of equity. So he who comes to equity must come with clean hands. Equity will suffer no wrong to be without remedy, and so on. We come and discuss these maxims briefly later on in this lecture. Now, in the course of time, there was unavoidable collision between the original common law and this new body of principles known as equity. So you could have a situation where what the common law was saying was at variance with what equity was directing. So therefore, for a long time, you had two justice systems: the common law courts, the King's Bench, the Queen's Bench, the common plea courts, exchequer, and so on. And then you also have the Court of Equity, which was really like the Chancery Division. So you have to go to the common law court, and maybe when you are not satisfied, you also come to equity. So that was not a very tidy situation. So between 1873 and 1875, in England, they passed what they call the Judicature Acts of 1873 to 1875. And all this legislation passed within that period were meant to bring about fusion between the jurisdiction of common law court and jurisdiction of court of equity, so that unlike the period before, where you had to go to a separate court to assess common law, and if probably still unsatisfied, you came to another court to assess equity. Now, from the Judicature Act of 1873, 1875, these jurisdictions were merged. And that meant that one and the same court would apply the common law and principles of equity at the same time. So the Judicature Act of 1873, 1875 is quite significant for the fusion that it brought. So mind you, it's not the case that common law and principles of equity were merged. No, that's not what we're saying. All that we're saying is that the jurisdiction of these previously separate courts were merged. And in effect, what it meant was that one court applied. Yes, there was a bit of a break. Can anybody remind me where you stop hearing me so that I know where to continue from? Can you put up your hand and I'll release you? So where did the line go off so that you couldn't hear me? Okay. Yes, Ako, you can unmute yourself. Oh, no, sorry. Ako, you can unmute yourself.
I think when you spoke about the Judicature Acts of 1873 to the 1875.
Oh, right. Okay.
I mean, you ended that, so we're moving to the next.
All right. Thank you. Yeah, so sorry for interruption with internet connection. Yes, so there have been a fusion of the common law and equity. And of course, here in Ghana, that has also been the situation right from the colonial period, post-independence up to the Fourth Republic. So let's take note of that. So as I indicated, if you observe the kind of justice which was being administered in the common law, in the Court of Equity, the Chancery Division, you could see certain principles which were observable. And these principles are what we call the Maxims of Equity. And what are some of them? That equity will not suffer a wrong to be without a remedy. So when we say that equity will not suffer a wrong to be without a remedy, that is to say that as far as the Court of Equity is concerned, so long as you have been able to prove, you have been able to demonstrate that you've suffered a wrong, that someone has violated your interest or your right, a Court of Equity had the capacity to provide appropriate remedy for you. And this is used in contradistinction with the common law. Now, as we saw in the case of the common law, where you have actually proven your case, all that could be given you was what we call monetary compensation, that is damages. But there are certain types of wrongdoings in which damages will not suffice. You may want some other things. So, for example, no equity can order specific performance, where you had a contract and the subject matter of the contract is said that even if monetary compensation of damages is awarded, the innocent party will still not achieve what he will have achieved if the contract had been performed. The court could order specific performance, injunction. Certain wrong has been done. The court can order that it should be undone and so on. Or the court can restrain the doing of it if it's yet to be done. We will have prohibitory injunction. mandatory injunction, perpetual injunction, interlocutory injunction, Anton Pele orders, and all that. So all these were some of the remedies which the Court of Equity could actually decree, so long as you have been able to establish that there has been an invasion of your legal or equitable rights. So let's keep that in mind. And that is why, if, for example, you look at the case of Tahiru against Mriku, which we have cited at page 103 of the book, where the defendant agreed to sell his house to the plaintiff for 250,000 old Ghana cedis. The payment was to be in installments, and in pursuance of this agreement, the plaintiff paid the sum of 125,000 old Ghana cedi, which was recorded in the receipts and payment table prepared in respect of the agreement. Now, later on, when the plaintiff paid the balance to the defendant, he refused to accept it on the ground that the plaintiff had delayed payment and he had subsequently sold the house to the co-tenant for 500,000 cedis. That is, if you like, times two the original contract price of 250,000. The plaintiff, who obviously felt cheated, sued, claiming for specific performance of the agreement and damages for breach. So it was argued on behalf of the defendants that the agreement, which was one which can be considered as a conveyance of an interest in land, then under the conveyancing decree, it ought to have been in writing before it could be valid. So this was an argument made on behalf of the defendant in that case. But the court held that the plaintiff, in terms of the then law, that is section 3, subsection 2 of the Repeal Conveyancing Decree, NRC Decree 175, the plaintiff made part payment of the purchase price, and the defendant made use of the money to the detriment of the plaintiff. And for that matter, if the agreement was not enforced, that will amount to fraud in the defendant against the plaintiff. And the court was of the view that the agreement could be enforced by a degree of specific performance. Now, somewhere in the judgment, the court, which was presided over by Justice Lamte, as he then was, made this statement, and I quote, "The attitude adopted by equity is that it will be fraudulent for a defendant to take advantage of the absence of a signed memorandum if he stood by and allowed the plaintiff to alter his position for the worse by carrying out acts in performance of the contract." So the takeaway from all these excursus is that equity will provide suitable solution, suitable relief or remedy once you have been able to establish that another person has violated your legal or equitable right. Another maxim of equity is that equity follows the law, but not slavishly. Now, this simply means that equity came to supplement the law. Equity did not come to supplant the law. So supplanting means that, like taking over, no. Equity did not come to abolish the common law. It came to supplement it. It came to mitigate the harshness or the rigor of the common law. And for that matter, where the common law is giving solution, which is fair, a court of equity will not, or the court in exercising its equitable jurisdiction will not intervene to give any other solution, because the common law is giving a fair determination. However, where the common law, for example, is not yielding fair outcome, fair results, then equity will make a departure. And that is why we say that, yes, if you want equitable remedy, you need to first establish a necessary legal interest, the legal title, and failing which equity will come in and say, okay, is there an equitable right? Is there an equitable interest? And so on. So equity would always agree with the common law and only make a departure where the common law is working injustice. So we've cited a number of cases in chapter 3 of the book. If you look at page 104 and 105, the case of Abe and Sky, we've discussed it. The case of Graf against the Hope Building Corporation, we've discussed it. The case of Amuzu and Okleka, we've discussed it. Yeah, another maxim that where the equities are equal, the law shall prevail. And this will usually happen, particularly, let's say that when it comes to land transactions and so on. Let's suppose that you have a land which two parties are claiming, and each of them are relying on some documents, in the document which have been registered and so on in some cases. So, but if you examine the facts, you notice that one is acting in good faith without notice of the fact that maybe the land had been sold and he has taken steps to regularize his title by obtaining the title certificate and all that. So in that situation, despite the fact that this person was even like second in time, he will be able to prevail. You'll be able to prevail against the other. But where the equities are equal, the first in term shall prevail. That is to say that where you look at the various competing interests, the various competing rights, especially with respect to like the same property. Now, maybe like we give you like a typical example, like what we have provided at page 106 of the book. Let's suppose that A buys a piece of land from B, but does not register as sale. B, however, sells this same piece of land to C. Who buys the land without knowledge of the fact that it was sold to A? But C did not also register his land. So if we look at it, it is the law that since A and C all have the same equities in respect of the land, the first purchaser's interest should prevail over the latter. Because if you take like the A, where did the B get his land from? B got his land from A. Now, when B got the land, he sold it to C. Now, when C bought it, C did not know that the land had also been sold to A. Maybe we take the case of Jima and Brown against in 3, which we have reported at the footnote 181, decided in 2005, 2006 Supreme Court of Ghanaian Law Report 247. That is where it is reported. The first defendant made a sale of the same property, first to the plaintiff's appellant, and then to the claimant, at a time when he had no title to pass the property. However, he later acquired title to it, and upon a dispute over the property, an action was instituted in the High Court by the plaintiffs, appellants. And the Court of Appeal, which reversed the High Court decision, held that the plaintiffs had failed to enter into possession of the property. And later on, the Supreme Court also reversed the Court of Appeal and applied the equitable maxim of where the equities are equal, the first in time prevails. And in the Supreme Court reasoning, the purchases were made at a time when the original seller had no title to pass. And for that matter, priority between the two equitable interests will be held. The original seller had no title, and as we said, I know that court non habit. You cannot give what you do not have, as it were. And again, he who seeks equity must do equity. If you are seeking the assistance of the Court of Equity, it doesn't mean that you should be saintly or you should be angel. No. All that it means is that you yourself must have also acted fairly. So therefore, if you have not acted fairly, then the Court of Equity will not come to your assistance, because you yourself, you are not doing equity. And typically when it comes to, let's say, illegal loans, you know the principle, estopi causa non oritio actio, that you cannot find an action upon something which is based or something which is illegal. So if the basis of the transaction is, for example, illegality, then you cannot seek assistance of the court. But of course, if you look at the illegality and public policy, especially the case of the Accra Metropolitan Assembly against City and Country and Waste, you notice that the Supreme Court, speaking through Justice Datiba, said that when it comes to effect of illegal contracts in Ghana, the orthodox common law position was that you could not recover, right? You could not recover that which had been transferred under, especially money. Now, the court said that we need to approach it, in a structured way, instead of just saying that money transferred under illegal contract cannot be, retrieved. Of course, at common law, we have the limited exceptions where you can prove that you are not equally guilty, you are not in pari delicto, or where you could prove that there had been a change of mind and heart on your part. That's what we call the locus penitentiae. Now, beyond all that, Justice Datiba was making the point that we need to look at it case by case. You notice that looking at the AMA against the City and Country Waste Limited case, all that AMA was saying was that having benefited from sanitation services provided by City and Country Waste, when they had to pay for the services, they now looked through the document and their records and said that, well, under our law, this contract was supposed to have been passed in a certain way, resolution rendered by the assembly and all that. And if that had not been done, then that is illegality. And for that matter, we shouldn't pay. But if we look at it, it is not City and Country, Country and City Waste Limited, which controls the internal legal processes of AMA. And here is the case, they have provided the service, and it is time for payment to be made, but they are now trying to exploit their own failure to comply with their law. So this is where equity will come in. They are not doing equity. And for that matter, equity will not assist them. And of course, related to that, he who comes to equity must come with clean hands. If you are seeking assistance of equity, you ought not to have also contributed to the very problem for which you seek the assistance of equity. So what we call the doctrine of clean hands. If your own conduct can be blamed in part for that which you seek intervention of equity, then you are likely not to be successful. So he who comes to equity must come with clean hands. But as I said, it doesn't mean that you must be sinless or you must be righteous in the heavenly sense. No, it is relative. And here you are referring to the fact that the very problem that you have brought to the Court of Equity for assistance, you yourself ought not to have contributed to it by the way you acted or you failed to act. Again, delay defeats equity. Delay defeats equity. You may have a legitimate interest, either legal or equitable interest and all that, where there has been breach or violation of it, and you don't act timeously, that may prevent you from getting remedy. In modern times, like this delay defeats equity, we have things like the doctrine of the laches, laches, acquiescence, adverse possession. So laches or lashes, where you have a right and you have actually allowed another person to put up certain conduct, which suggests that as if you did not have that right, and you wait for a reasonable period of time to elapse, then where the other party has actually incurred certain expenses or certain detriment, it will not be equitable for you to actually assert it. Now, in modern times, we have the law of limitation of action. So in Ghana, for example, we have the Limitations Act, NRC Decree 54, which has prescribed time frame for different types of cases. For example, when it comes to, let's say, land, if you look at Section 10 of the Limitations Decree, you will notice that where someone has actually made adverse possession, has entered onto your land openly, consistently, he has remained on the land for a period of 12 years without any challenge or protest, then that will lead to extinguishment of the title of the original owner. Equality is equity. Equality is equity simply means that where 2 or 3 people have got an interest in something, but there is no prescribed formula in the first place, equity will assume that it's supposed to be shared equally 50-50, that is one. And again, when it comes to tenancies, different people holding interests together, the common law used to have what we call the joint tenancy. Now, joint tenancy had a certain feature, what we call the jus accrescendi, or the right of survivorship. So what it meant was that if, let's say, 4 people had a property, if one person dies, that person's interests would actually be taken over by the surviving 3. If the next person died, the surviving 2 will take over that. And then eventually, everything will become the sole property of the last surviving person. Now, that is a bit harsh. So we have what we call tenancy in common. So tenancy in common, there is the right of survivorship. That is to say that when you have like property interests with other people and you die, the fact that you have died will not mean that your interest has actually been taken over or have been added to those who are surviving. No, your estate will continue to benefit from your interest. And that is why, if you look at the Interstate Succession Law, PNDC Law 111, you notice that it has also endorsed tenancy in common. If you remember, for example, there's a provision that where a person dies, survived by the spouse and the children and all that, and if he has a house, one of the houses, the first one, will be taken by the surviving spouse and the children, and that they hold it as tenants in what? In common. We hold it as tenants in common, as it were, and not joint tenants. Of course, if you look at the Land Act, it also, just as the Repeal Conveyancing Decree, also preferred tenancy in common to joint tenancy. Again, equity looks to the intent rather than the form. So that is to say that equity is less concerned about formalities than substance. It is the substance which matters and not the form. So, for example, if you look at page 110 of our book, we cited the case of Fofie and Zano, and also the case of Parkin and Toro. In Fofie and Zano, for example, the court held that, quote, in equity, it is the essence of the transaction that the court is concerned with and will admit extrinsic evidence to satisfy itself with the transaction and not merely the words used in the instrument. In other words, equity looks at the substance of the transaction and not merely at the form. So I'll give you an example. For example, if we take, let's say, probably like when it comes to court proceedings, we have affidavit. The person who actually, makes the affidavit is called like the deponent. Now, we also have what you call like a witness statement, okay? So someone, for example, makes a witness statement which he intends to use during a trial. But instead of writing where he signed, instead of writing witness, he writes the word deponent. Now, if you are going by common law technicality, you say that once you didn't use the word with a witness and use the word deponent, then that is not valid. No, equity will look at it. Is the person saying the same thing as a witness will do? And if that is so, then it doesn't matter so much regarding the form. So equity looks to the intent rather than the form. Again, equity regards as done that which ought to be done. Equity regards as done that which ought to be done. And what does that mean? That is to say that as far as equity, is concerned, equity can look at a conduct which has been put up. And in that conduct, equity can infer that the person who acted in a particular way intended to fulfill a certain obligation, despite the fact that he might not have explicitly stated it. But if that will be inferred, that will be it, despite the not maybe formalities or technicalities having been observed as it were. And if we look at the case of Walsh and Lonsdale, and you remember it's a very good case to cite when we are discussing this particular maxim, that equity imputes an intention to fulfill an obligation, or equity regard as done that which ought to be done. In the case of Walsh and Lonsdale, which we've again cited at page 111 of our work, the defendant Lonsdale agreed to grant the claimant Walsh the lease of a mill for 7 years, and the rent was to be paid quarterly in arrears, with a year's rent payable in advance if demanded. The parties did not execute a deed for the grant of tenancy, but the claimant moved in and paid rent quarterly in arrears. The defendant then demanded a year's rent in advance, and the claimant refused to pay. The court decreed specific performance in the landlord's favor. And the court, speaking through Lord Jessel, made the point, quote, "The tenant holds under the same terms in equity as though the lease had been granted. He cannot complain of the exercise by the landlord of the same right as the landlord would have had if the lease had been granted." Yes. So you see, equity is regarding as done, which ought to be done. So for example, if you really made like a contract and the contract was subject to, like you've made the agreement was like subject to contract, meaning that you expect a more formal thing to be done. If subsequent to making the agreement, which is subject to contract, you put up behavior which suggests that as if the formal contract has made. Now later on, when there is any breach, equity could say that insofar as you were behaving as if the formal contract which you expected to sign had been signed, then equity is going to treat both of you as already having entered into that, especially so when you are conducting yourself according to the terms of it. Or illustrate it differently. Let's suppose that there's a draft contract, okay? A contract that maybe one person has signed, the other is yet to sign, and both parties continue to behave towards each other as if the contract had actually been signed, when the matter of reality, it has not been signed. Now, despite the fact that it has not been signed, equity will still treat the parties as having bound themselves by that contract, especially so when their actions after the signing of the contract by one of them will suggest that both consider themselves as bound by the contract, as it were. Again, equity also acts in personam. Of course, before that, we've said equity regards as which ought to be done. So let's suppose that I owe you 1,000 Ghana cedis, and I pay you 800 Ghana cedis, right? But I don't state that this 800 Ghana cedis is towards the payment of the debt that I owe you, at least to the extent of whatever part you can pay. Now, later on, if you should sue me for recovery of the full 1,000 Ghana cedis, if I can bring evidence to show that I gave a certain 800 cedis to you, now they didn't even indicate that it was towards payment of the debt that I owe you, equity would impute an intention on my part to fulfill my obligation of paying the debt that I owe you. So that the 800 cedis that I paid, even if I wasn't explicit, will be treated by equity as having been paid in pursuance of the debt that I owe. So equity imputes an intention to fulfill an obligation. Again, equity as in personam. When we say equity as in personam, that is to say that equity acts on the person rather than his property. We have personam and in rem. Persona means that equity acts on the conscience of the person. But if you say in rem, that is to say that it's acting on the things belonging to the person or the property. No, equity acts in persona. And that is the foundation of equitable remedies: injunction, specific performance, rescission, rectification, and all that. Now, if you do not honor orders or decrees of equity, you could be arrested and then you'll be dealt with. You can go to prison. So equity acts in personam. Equity acts on the conscience of the person. And for that matter, equity would only grant orders where the orders can be supervised, can be enforced. Like if it said that an injunction, for example, cannot be enforced or supervised, then it will not be granted, because equity is in personam, and equitable decrees are supposed to be obeyed as it were. So if we look at the case of Penn against Baltimore, for example, which we have cited at page 1112 of our work, specific performance was granted relating to boundaries of land in America. Although, if you ordinarily come to English court, it will not entertain an action relating to movable property situated outside the jurisdiction. Yes, because it's about specific performance is directed against the person, the conscience of the person. If the person does not respect it, the person can be cited for contempt of court, and you could go to prison. So these are some of the principles which actually govern the equity and the various remedies that it gives. So what are the remedies available in the court of equity? What are equitable remedies? So we have rescission, injunction, specific performance, and rectification. So rescission is an equitable order we seek to set aside a contract due to misrepresentation, mistake, duress, or undue influence, as you know. And then injunction is an equitable order which seeks to restrain or compel actions, like prohibitory injunction, for example, looking into the future. If a wrong is about to be committed, it's not been committed yet. Mandatory injunction, where a wrong has been committed but it has been reversed. Interlocutory injunction, and also interim injunction. Those are injunctions which are granted when you have a cause of matter which is still pending before a court. And then perpetual injunction, that is permanent injunction, is granted after the court has gone into the merits of the matter and has determined who actually has the particular right and so on. And then Mariva injunction and Anton Pele orders, these are used in enforcement of intellectual property rights. We also have specific performance, a decree of a court of equity compelling performance of contractual obligation. And of course, equity actually developed what we called assumpsit. Assumpsit was a particular cause of action which existed in the common law. So by specific performance, the court of equity is saying that you made agreement to do this particular thing, so carry it out just as you agreed. Then rectification is an order given by a court of equity which seeks to correct mistakes in written document to reflect the true intention of the parties. So sometimes there will have been an oral agreement and is subsequently reduced into writing. What is written may not accurately reflect which the parties agreed at the oral level. So it may be necessary for rectification or correction to be done. Yeah, so let's say them one after the other. So as we have indicated, rescission is a setting aside of a contract to restore the parties to their original positions. So therefore, rescission will be granted only where it is possible to restore the parties to their position before the contract was made. If they cannot be restored to the position before the contract was made, then rescission will not be granted. What are some of the basis or the reasons for which rescission will be granted? Where there has been misrepresentation. So where one party is saying that, yes, I entered into this transaction as a result of false statements made by the other party to induce me to enter into the contract. Maybe as happened in cases like dairy and pig and so on. Then the court will grant rescission. Or where there has been a mistake. Both parties, for example, hold different understanding regarding fundamental aspects of the contract. That can also give rise to a mistake, and that will be a ground for rescission. For example, what happened in the case of Kutura and Hester? Both parties, the vendor believed in honesty that he had the subject matter of the contract, which was on its way from the high seas, when in fact it has ceased to exist. And then the purchaser also believed that, yes, he was contracting to buy a particular corn or items on its way coming, when it has ceased to exist. But these people did not know. So that was a contract res extincta. The subject matter had actually ceased to exist, unbeknown to the parties. Or in some cases too, where you have unilateral mistake as to identity of the other contracting party, where one party enters a contract and he has been deceived, he thinking that he's entering the contract with A, when in fact it's not A that he's contracting with, by a rogue who has interposed himself as A. Now, subsequently, when he becomes aware and there has not been intervention of third-party rights, the court can allow him to get the contract set aside or cancelled. Another ground is duress, where one party is forced to enter into a contract under threats, unlawful pressure. That can also be a basis for the order of rescission. And then undue influence, where one party exploits their influence over another to gain an unfair advantage. They will presume undue influence, actual undue influence, as the case may be. All these are legitimate reasons for the grant of rescission. Yeah, so to exercise the right of rescission, the party seeking it must notify the other party of their intention to rescind the contract. So notification is important. Rescission is not something you keep to yourself and say that I am rescinding. No. When you became aware of whatever is leading you to ask for the rescission, they do notify the other party. You need a legal action in some cases to pursue the remedy of rescission. But the most important thing is a notification. So if we look at the cases of especially the unilateral mistake as to identity. Remember the case of Lewis and Ivory, Ingram and Little, Kens Norton, Meta, Bolton and Jones, those type of cases. Once you have been swindled, as soon as you become aware, you must notify. If it's not possible to notify the other party, sometimes you need to notify the police as a way of showing that you did something overt, that you were considering yourself as no longer bound by the contract. But of course, it's not all the time that the right of rescission will be available. the remedy of rescission will be available. So what are some of those instances which may serve as a bar to prevent the grant of the remedy of rescission? Well, maybe you have an absconding party where the party who is responsible for whatever is leading you to get the rescission abscond and it's not possible for you to effect rescission by some reasonable overt act, then that could be a problem. But if it's possible for you to, let's say, bring it to the attention of police, maybe do some public notice and so on and so forth within appropriate time, close to when you became aware of the fact that you have been a victim of misrepresentation, mistake, undue influence, as the case may be, then you need to do that. Another bar to the remedy of rescission is impossibility of restitution. So where you have restitution integrum, it's not possible for you to return the parties to their position before the contract. Then rescission will be refused. Maybe, for example, maybe where the subject matter has been consumed or has been commingled with other things and so on. Affirmation of contract. If you are the innocent party, you become aware of whatever is entitling you to seek, rescission, but you decide to act in a way which suggests that you have affirmed the contract. That would deprive you of the right to rescission. Again, lapse of time. Where you delay in seeking rescission, that could also disentitle you to rescission. Don't forget, time is of the essence when it comes to equitable remedies. And delay defeats what? Equity. You have to be timeous. Then intervention of third-party rights. Where you entered into transaction and the transaction is initiated by, let's say, rescission. But then an innocent third party subsequently acquires a right in a subject matter in good faith, in the sense of without having any knowledge, direct or constructive, regarding regarding like the mistake or the misrepresentation, duress or whatever, then the right of rescission cannot be what? Exercised, because it's not possible to even restore you to the original party. A third party has come into the picture, as it were. Maybe you look at the cases like car investor finance against Cardwell. You remember from your law of contract, where the person who was seeking the rescission notified the police and also the automobile association when the other party whose conduct was responsible for the rescission had actually absconded. Again, we've made the point that where you become aware of the situation entitling you to rescission, but you behave as if you have forgiven it or as if you have condoned it, what we call affirmation, then your affirmation will prevent you from later on asking for rescission, because you'll be doing what we call you are approbating and reprobating. You cannot approbate and reprobate, or to put it in everyday language, you cannot eat a cake and have it back. You cannot say that, oh, I have been misled to enter into this contract, and at the same time you behave normally under that contract, having even become aware. Then later on, you cannot say that the contract should be cancelled as it were. We also have the equitable remedy of injunction, and as we have explained, is a court order which restrains a party from doing certain acts, like prohibitory, or compels a party to do certain acts, mandatory, either to do certain acts or even to undo, certain acts, reverse certain wrong which has been committed. And the objective is to prevent harm or to compel action to protect legal rights. So that is the point about injunction. So in our book, we still discuss the various types of injunction. So prohibitory and mandatory, as we have said. Prohibitory, an order restraining a party from continuing a course of conduct that infringes on another's rights. So, of course, there's also what we call the Kwarteng, right? Kwarteng, where, for example, you have a transaction with someone, and then the person has threatened to, breach it, or has threatened to commit a certain wrong. You could also get injunction. So that is the Kwarteng injunction, which is a species of the bigger category of prohibitory injunction, as prohibitory injunction actually seeks to restrain or prevent a person from committing a wrong which he has not committed yet. So it is more or less, if you like, futuristic. It looks into the future. Maybe if you want to prevent your neighbor from building a disputed land, your neighbor has not built yet. So that is prohibitory. You should not go ahead and build. We also have mandatory injunction, which require a party to perform a specific act to rectify a wrongful situation. You see, it's not the same as specific performance, but mind you, specific performance is limited to only contract. It is only in respect of contract that you can have the degree of specific performance. However, mandatory injunction can be applied to so many transactions or so many situations. For example, there can be mandatory injunction to compel demolition of an illegally constructed building. Now, the building you have constructed already is illegal, so that is the wrong. You can be ordered to undo that wrong, that is by demolishing it. And that is an instance of mandatory injunction. Then, in terms of duration and timing, we have interlocutory injunction on one hand and perpetual injunction on the other. So, interlocutory injunction is a temporary order to maintain the status quo pending the final determination of the case. So, if we look at Order 25 of CI 47, that's the High Court Civil Procedure Rules, it provides for interlocutory injunction. Now, where the court considers it to be fair and just in the circumstances of the case, the court may grant interlocutory injunction and an order to maintain the status quo pending final determination of a case. So the main purpose then is to prevent irreparable harm during litigation. So you don't want, certain things to be done which will be extremely difficult to reverse if at the end of the litigation, the party who is doing it, for example, is a losing party. So you may want the situation to be frozen until the case is concluded. So you achieve that by interlocutory injunction. Then somebody wants to ask, what about interim injunction? Well, interim injunction is an aspect of interlocutory injunction. Now, within the context of our civil procedure rules, especially CI 47 or 25, interim injunction is an injunction which is granted for a period not exceeding 10 days. So it is, if you like, a limited injunction, as it were. After 10 days, it will lapse. An interim injunction can be obtained by ex parte application. That is, only one party who goes to court and asks the court to grant it. Interlocutory injunction any injunction which is supposed to last until the end of the hearing of the case, that will have to be on notice and not ex parte. Then we also have perpetual injunction. And perpetual injunction is a permanent order granted after the determination of the rights of the parties. So when the court has gone into the full merits of the case and know who is entitled to what and all that, then the court will go ahead and grant perpetual injunction. So if you look at a lot of land suits, you will see the reliefs. You first probably see declaration of title to a particular identified land. Then the next one will probably be recovery of possession. And then the third one will be perpetual injunction, restraining the defendants or his agents, assigns or privies or successors entitled from interfering with the present enjoyment of the land, and so on and so forth. So that is perpetual injunction, and it comes at the end of the hearing of the case. Injunction, which comes during the hearing of the case for the entire period, is called interlocutory injunction. An injunction which is just for a short period, for maybe about 10 days, and what can be obtained on ex parte is called the interim injunction. And if you look at that 25 of CR 47, then we also have specialized injunction, Mariva injunction, and then Anton Pillay injunction. So Mariva injunction, also known as the freezing injunction, is an order to freeze a defendant's assets to prevent the defendant from dissipating those assets before a judgment can be enforced. So if you do not want the defendant to actually dissipate the assets which you can enforce a judgment against, you can move the court to grant Mariva injunction. For example, you can get Mariva injunction to freeze a bank account to secure funds for potential judgment. You cannot get Ganeshi when you don't have like a judgment. You must have a judgment before you can have Ganeshi. But you can get Mariva injunction even while you are yet to get a judgment. And the injunction actually came from the case of Mariva Compania Navera against International Board Carriers. That we also have another specialized injunction. Another special, yeah, Zach. Yeah. If you want to go, okay, I'm online. You can go. All right. Yes. So we also have Anton Pillay order, which is known as the search order, and it is actually used in intellectual property, rights enforcement, especially. What does it do? Anton Pillay allows a plaintiff to enter the defendant premises to inspect, photograph, or take custody of evidence. So maybe like copyright, infringement, and so on. Somebody is violating your intellectual property right. You need to take the person by surprise. You need to get the evidence, because without the evidence, you cannot actually pursue enforcement in court. So Anton Pillay, which is a special search order, will allow you. And it's usually obtained on ex parte because there has to be an element of surprise. If the defendant is aware that you are going to come, he or she may hide the evidence, which we need desperately be able to make your case of infringement of your intellectual property against that person. So maybe like counterfeit goods and other things, for example, you need to get the evidence. Maybe your trademark or some other things is being violated. And it came from the case of Anton Pillay against Manufacturing Processes Limited. So what are the conditions for obtaining or for the grant of injunction? First, there should be serious issue which is to be tried. So the applicant must show that there is substantial issue to be determined by the court. So that is very important. Otherwise, you will not be giving the injunction, particularly so when this is like the interlocutory injunction. Then the balance of convenience. The court must determine that the balance of convenience favors granting the injunction than refusing it. So that one is a weighing exercise which the court will give. And then it must also be shown by the applicant that irreparable harm will be suffered if the injunction is not granted. And what is irreparable harm in this sense? Irreparable harm in this sense is in relation to inadequacy of damages. That is to say that if the injunction is not granted and certain things go on, monetary compensation will not be enough to remedy it. Then undertaking in damages, if you look at Order 25, one of the requirements for the grant of interlocutory injunction is undertaking in damages. The applicant must agree to compensate the defendant if the injunction is later found to be unwarranted. So for example, I am building my property, you sue me, you want the court to injunct me. Okay, the court says that we are going to injunct the person. What about if at the end of the case, it turns out that you had no case, no good case against him? You have wasted the person's time. It will have become more expensive to build and all that. So the law is that the applicant seeking the injunction must make undertaking that he or she is ready, willing, and able to pay any damages or any losses which may have been suffered at the end of the case if it turned out that the injunction ought not to have been granted because the person does not have good case. But let's keep that in mind. If you look at our book, there are a number of cases which we have also provided there. When they are adopted against Ernest Arimayu, Ernest Ekuampianim, Nippon Yusen Kaja, and of course, the case of Anton Pele. Specific performance, because you are all expecting law of contract, you will not believe at the point here. So you've explained that specific performance is an order or decree of the court exercising equitable jurisdiction, which is to compel a party to perform its obligation under a contract. And it is a remedy in rem, I mean in personam, not in rem, sorry, in the sense that it's targeting the individual rather than the property. And if the individual does not comply, he or she risks contempt of court and he or she can go to prison. So before the court will grant specific performance, there must be evidence of existence of a binding contract. It must be shown that yes, there was a contract, because mind you, specific performance is a remedy which is limited to contract. The other equitable remedies, not all the time that you must have a contract, but this one, there must be a contract. So that is important. And that is why the case of Short and Morris will emphasize that specific performance requires a binding contract. Another requirement is that the person seeking specific performance must prove that damages are insufficient to compensate for the breach. And here you remember we said that equity follows the law, but not slavishly. The law will give damages. Now, where damages will not be adequate remedy, then equity will make a departure and grant some other remedy, including specific performance. So, for example, when it comes to contract involving unique properties, such as land, for example, it is said that no two parcels of land are the same. And the reason is simple. The location of land determine the various utility or the various uses to which the land can be put. So that if you have a land at, let's say, Airport Hills, what you can do is different from if you have the land at, let's say, Oyarifa. They are not the same. So we have to take note of that. Another requirement is mutuality of obligations. Both parties must be able to perform the obligations under the contract. So if it can be shown that only one party could perform its obligation, if you really wanted to perform, then the specific performance will not be granted. Because it works both ways. You are saying that a party should be made to perform what he undertook under the contract. If that is so, then you, the person also asking, you too should have already performed your side. And of course, there should be clarity of the terms of the contract. There shouldn't be vagueness so that we know exactly what is expected of the parties. Now, there are situations in which specific performance will be refused by the court. For example, when it comes to illegality, such as immoral contract. So, for example, if you have a contract with, let's say, a commercial sex worker or a prostitute or escort to have something to do as a result of payment of money, and the person does not pay the money, or the person does not agree to do the act, so that you go to court. You want the court to order the other party to specifically perform the contract. That will be refused because that is illegal. That is immoral. You can look at the case of Erwin against Osbaldeston. Also, a contract which requires constant supervision is not a contract which will be specifically performed. If there's a need for continuous oversight, then the court will not grant specific performance. I'll give you a typical example. Let's say employment contracts or contract requiring personal services. It's difficult to actually supervise as whether it's being carried out. So the court will not grant specific performance. And then, of course, we've stated that there's mutuality. So where mutuality is lacking, the court will not grant specific performance. So that if you take contract involving minors, right, or infants, for example, if you look at the authorities, a lot of them, Nash and Iman and so on, imperial loans and all that, Di Francisco and Ban, we are told that where the contract involves a minor, the minor will only have to pay reasonable price, assuming the goods are deemed to be necessaries and all that. So what it means is that you cannot get the minor or the infant to pay the agreed price under the contract. So there is no mutuality. And because there's no mutuality, a minor or an infant to a contract can also not get specific performance decreed. Of course, where there will be undue hardship to the defendant, the court may refuse specific performance, and the court will have to balance the equities and assess potential hardships in every situation before it will make up 8 months to grant or refuse specific performance. And again, as we have stated, where damages will be adequate, specific performance will not be granted because equity follows the law. Specific performance will only be granted where damages will not be adequate. And for that matter, equity will not follow the law slavishly. It will make a departure. Yeah, so we've given some examples where specific performance will be granted. We've talked about them. If you look at our book, we've cited the case of Amuzu and Okreka, Latte and Bannerman, Short and Morris, Owusu-Dapaa, and Sit Hotels Corporation. So if you look at chapter 3, all these are discussed over there. Then let's talk about rectification. Rectification is another equitable remedy that corrects mistake in written documents to ensure that the written contract or document aligns with the original agreement and intention of the parties. So an understanding is that the parties' true intentions are not reflected in the written agreement. So the written agreement needs to be corrected to effectively reflect the true intentions of the parties. So it will be granted where the following conditions are present. There should be a prior agreement. That is to say that there should be evidence of clear oral agreement, as it were. Like maybe we had a pre-contractual negotiation on terms discussed and agreed upon, and subsequently it was reduced into writing, and the written version was found not to reflect the prior agreement. And in that case, there will be an exception to what we call the parole agreement rule or the parole contract rule, which says that extrinsic evidence will not be admissible to vary or contradict the content of a written agreement. So that will be an exception. And of course, there must have been common mistake. That is to say that both parties made a common mistake in the document. Meaning that where the mistake is unilateral, only one party has made a mistake, then specific performance will be refused, as happened in the case of Riverlet Properties Limited against Paul. And again, the written agreement must have been intended to reflect the prior agreement, but it failed to do so due to a mistake. So that's what we've explained. Then obviously, rectification will be declared as it were. Yeah, so rectification can be assessed as a remedy through court proceedings, really, because without court proceedings, it cannot be officially been ordered. So there will have to be evidence brought of the original agreement and then the mistake. So you need documentation of prior negotiation and agreement or some recording. Maybe this is maybe chat, text messaging, recorded conversation and all that will be a way of proving that yes, at the oral level, this is what we agreed upon. But the subsequent written agreement you have signed does not reflect that. So let us rectify it to reflect it. Emails and all that will be useful way of proving it. So the court has a discretion, just like all equitable remedies, so to examine the circumstances and make a determination. And in all this, the court will seek to achieve the virtues of honesty and also ensure fairness in the conduct of both parties. Of course, there are limitations. That is a situation in which rectification may not be granted. As we have said, it will not be granted where the mistake is by only one party. That is to say that a party cannot seek rectification if the other party was unaware of the mistake. And of course, where there's also been intervention of third-party rights. Maybe some purchasers have relied on the original document, which you are complaining contains an error need to be rectified. Because third parties have relied upon it, it will no longer be available for what? Rectification. And again, delay also, just like any other equitable remedy, and we say delay defeats equity. Excessive delay may also be a bar to the remedy of rectification. And of course, where it is not possible to achieve restitution, where it is not possible to get the parties to be at the position that they were before the document rectified was actually prepared, then that may also be referred because there will be undue hardship or to be impractical, as it were. Yeah, so we have the cases that we have cited in the chapter 3, so you look at all of them. So as we have indicated, the common law, which we have discussed so far, and how it's also metamorphosed into the fusion of the jurisdiction of the common law and equity per the Judicature Act of 1873-1875. That common law made its way to Ghana with the colonization. And remember how gradually colonization of Ghana started gradually with the bond of 1844 between the chiefs of Fante and then Captain George McLean and the other colonial officials. And how later on the British extended their law beyond the forts into the community. And subsequently, we had the Supreme Court Ordinance of 1876. And the Supreme Court Ordinance of 1876 actually stated the common law and equity as part of the body of laws or the corpus of laws that were applicable in the then Gold Coast, as it were. Now let's talk about the last component of the common law of Ghana, and then we are done on the discussion of sources of law. So we have the customary law. So if you look at the Constitution, the customary law is defined as the rules applicable to particular communities in Ghana. Rules applicable to particular communities in Ghana. So if you look at the page 126 or 127, we've discussed all that up to 129. Initially, the existence of customary law, that is a rule of customary law, when there was an allegation as whether something was a rule of customary law, it was initially assessed as a question of fact. And what does that mean? When it comes to trial, we have two types of questions. We have questions of facts and questions of law. Questions of facts are tried or resolved by, if you have a judge in a jury trial, then the jury will determine that. Or if you have only a judge who is sitting as the sole arbiter, then the judge will determine both questions of fact and questions of law. And questions of fact are determined strictly according to available evidence before the court. Questions of law, we are told the law lies in the bosom of the judge. So the judge will have to do his independent research and then address the relevant questions of law. However, initially, when there was an allegation as whether something was a rule of customary law, it was treated as a question of fact and not question of law. And that was supposed to be based on the evidence of the custom, general knowledge, and acceptance. So that later, if you look at what that became known as the rule in Angu Investigata, that questions of customary law are questions of fact, and it have to be proved by evidence unless it has become so notorious before it may be excused from the requirement of being proved like any ordinary allegation. But currently, questions of existence of customary law is a question of law and not question of fact, and it's determined by the courts. And another point worth noting is that all customary law must be in harmony or must be in alignment with the provisions of the 1992 Constitution. And for that matter, any customary law that contradicts the Constitution is void to the extent of the inconsistency. So let's note that. Well, in terms of scope and application of customary law, there are a lot of areas, but broadly, when it comes to succession, inheritance and transfer of property within the various communities, customary law is visible there. When it comes to land ownership, if you look at the areas like acquisition, use, and transfer of land, customary law is quite important. If you look at our Land Act, if you look at our Land Act of 2020 at the 1034, you will notice that when it comes to the listing of interests in land in Ghana, about half of them are interests which originated from customary law. Again, when it comes to marriage and divorce, we also have customary law being important. Then when it, of course, customary offenses, we still, despite the fact that Article 19 of the Constitution has stated that no person shall be tried and punished for a crime or offense unless him has been defined in a written law with the prescribed punishment. Now, that notwithstanding, if you look at the Chieftaincy Act, and of course, I am mindful of the case involving Ampofo. Now, if you look at our Chieftaincy Act, there are still, some, even if not offense in the sense of the way offenses are understood under our Criminal Offences Act, we still have some customary offenses. For example, it is a taboo to go and have sex in the bush. That is a customary offense. And the courts play important role in interpreting and applying customary law. And that is why in defining customary law, you notice that reference were made to also aspects which have been determined by the superior courts. So the court makes use of decided cases, textbooks, and other writings to make the determination as it were. Yes, so if you look at our book, we have looked at the pre-1992 approach to customary law. And if you look at the situation since the First Republic, 1960, 1962, I'm just going to be jumping through because you get the book and then you read. Yeah, so we have also discussed the relationship between customary law and the Constitution in our book, and we have made the point that customary law must not contravene constitutional provision. And we've also noted that the courts are supposed to interpret customary law in the light of constitutional principles. So if we look at the case of Foley Date against the Republic, for example, where a custom was invalidated for contravening natural justice, as it were. But we also argue that customary law coexists with statutory law. And a typical example is the area of land, as we have noted. they are only subject to constitutional scrutiny to ensure that they do not undermine the letter and the spirit of the Constitution, as it were. So we've mentioned the case of Angu versus Atta, University College of Capos against Anthony, Folidays against the Republic. All these cases are in the book, so when you get the book, you will read them. Yeah, so I'll pause the discussion here. If you have any question, you can raise up your hand and ask it. Otherwise, I'll draw down the curtain. Yeah, I haven't seen any hand up, so I assume there's no question. Okay, let me stop the recording so that